Hi, everyone. Good morning. Thank you so much for joining us today. We are really excited to talk with Alan today about all of these changes to the marijuana reclassification from Schedule 1 and what that's going to mean for the industry. Just a few housekeeping items today. Remember that we have a chat bot set up, so anyone who wants to hop over and say hello and let us know where you're from and ask some questions, we'll be glad to lift those up to Alan and Mark, and would love to talk with you more there. And as a reminder, always, we will record this webinar and we'll share this afterwards. So no worries about missing information. I mean, feel free to take notes, but we'll send you the replay afterwards. And also for anyone who is a certified director of safety or certified safety supervisor through the NATME organization, we love NATME. We're very proud to support that organization. And this webinar is helpful for some continuing education points. So if you need a certificate after the webinar, let us know and we'll send that over to you too. And I think with that, let me get to the main event, to our speakers today. We have, of course, Mark Ray, who joins us often. Mark, how you doing?
Fantastic. Looking forward to today's session as we can discuss how we can, or the reality of this marijuana reclassification issue that's out there. It's a very confusing, and we're really lucky to have Alan with us today to set the record straight. Opportunity to give a good intro to Alan. He's got 25 years of experience in the drug and alcohol testing business. He's been a speaker at the TXTA, Texas Trucking Association, Texas Aggregate and Concrete Association, Texas Towing, and has done several webinars and information exchange activities on impairment drug testing. And I might add, he's a letterman, football letterman from the TCU Horned Frogs. So we're really glad to have him here today.
Thank you. Go Frogs.
Yes. And Alan, thank you for joining us. It's been a couple webinars with us now. So thanks for coming back.
Thank you. I appreciate very much the opportunity to speak with everyone. The meeting of today is about marijuana reclassification and what effect it has on the industry and what it does not have effect on the industry, and in general, how we approach going forward with marijuana. The first slide is about, scheduling marijuana from Schedule 1 to reschedule to Schedule 3, the impact it has on the industry, the positive part of it, the problematic part of it, and how federal law has affected everything. The first slide there talks about, I'll back up one thing. Back on May 16th of 2024, the Justice Department's formally brought forward a petition to regulate to move marijuana to Schedule 1 to Schedule 3. Back on December 18th of last year, President Trump gave an executive order to the DOJ to move forward with that transition. The negative or plus about this is, even though President Trump gave an executive order to move forward, all he did was make the suggestion to move forward. So really nothing has really transpired right now. Every Department of Justice, the Homeland Security, you name it, IRS, all these departments have little different readings on how they classify marijuana. The biggest plus about this is until this is finalized, marijuana will remain in Schedule 1 under the DOT complete rulemaking. So it doesn't change anything. It doesn't make it legal on the federal side of it. So without unless you've got a FDA approved prescription right now, which is only a couple of them out there, it remains a illegal drug to use. Let's turn the page, please.
Just to backtrack, the fact is the president has put out a transition order to move marijuana from Schedule 1 to Schedule 3, but that has not yet happened.
That's correct. That's correct. Correct. The biggest benefits, and we'll go the pros and cons of both. The biggest benefits of the pros for having marijuana to classification Schedule 3 is really the medical use. Right now under Schedule 1, there's so many different guidelines you have to go through to get medical approval for use for different type of physical problems you might have with you, from arthritis to cancer treatment, whatever. So moving marijuana closer to Schedule 3 helps in that situation. The problem we run into, again, from the marijuana part of it is that the research on it has been so regulated that it's a problem with making sure that cannabis, and that's the problem. It's two different types of marijuana, cannabis and hemp, and they classify it differently. So cannabis is a part of marijuana, where hemp is part of the stem and everything. How the rulings affect us, again, from the DOT side and the FMCSA side, marijuana is still prohibited. It's still a drug that cannot be removed from the DOT paneling. It's still a positive part of it. The next slide, please. And we discussed this one, so let's move on to the next one, please. Okay. The concern they run into is that right now, under the DOT guidelines, only drugs that are Schedule 1 and 2 are tested under the DOT guidelines that your panel you see, the 10 panel you see. The concern that's popped up is, okay, what happens if we move it to there without any classification? Technically, you could get a situation where that the federal government will not test marijuana. I don't think that's going to happen. The American Trucking Association, the NTSB, is 100% behind still staying marijuana as a Schedule 1, even though it could move to Schedule 3. And the reason being, again, the safety of the trucking industry. A couple of things that will make I just pause, I lost my place here. A couple of things that makes Schedule 1 different from Schedule 3 is, right now, marijuana, Tylenol with codeine, there's some steroids that are part of Schedule 1 that are now in Schedule 3. So again, putting in the classification of Schedule 3 will help on the research side of it. The next slide, please. Go to 4, please.
You talk about that being an industry alarm. I think that's a motoring public alarm, isn't it?
Yes, it is. The problem that we're seeing in the industry is that we have companies that have DOT and non-DOT customers, clients, that on the DOT side, obviously they think, well, because I've got a medical reason, I've got a medical prescription that I can use the marijuana. On the non-DOT side, I have customers that actually have removed marijuana from their testing because of the concern about that part of the medical side of it. But again, you look at all the states across the country, I think there's 24 plus District of Columbia have some type of legalized marijuana for recreational for use at certain levels. That doesn't make it legal for the industry. Just because a state might say, okay, you can have so much marijuana in your possession. Good example, you go to Colorado and you do something up there, you come back to Texas and it's illegal in Texas, you get pulled over in Texas, you're in trouble. Even if you work for a company that you're in Colorado for the vacation, you came back to Texas, you're non-DOT and you're tested and you're positive marijuana, and Texas is the no-call state for firing, so you still can be fired for using marijuana. So there's a lot of complications regarding changing from Schedule 1 to Schedule 3. But the biggest potential, again, was back to this right here, is the recognized potential medical use and the lower risk of it. There are studies out there that have shown that and everybody has a study, I guess, but they're shown that long-term use of marijuana does have some effect on the individual. So again, I know even though marijuana was officially put as a legal drug back in 1970, we're still in this issue nowadays on what can be done about it to help it. The biggest thing on the research side for Schedule 3 is that right now there is no benefits for research, or no benefits for selling it as a business. So this if it does go into effect and it goes to Schedule 3, then again open those regulations, and then from the tax side of it for people who sell it, there's obviously some benefits to it. Next slide, please. Let me get to my next slide here. Another slide, please. I've talked ahead of myself on this schedule here. Right, the panel. That next one, please.
Okay.
Right. Okay. Right there. Again, let's discuss in the summary everything before we move on. Is that the use of marijuana is a tremendous value that the industry sees for medicine, for marijuana, for research, for developing for medical reasons. For industry wise, it has no effect on us because on the DOT side, because the FMCSA has not changed the rules, or the DOT has not changed the rules. So impact of a driver's fitness hasn't changed because it's still illegal. Again, from the research part of it, it opens avenues for studies, for financial services. But again, from the DOT side, it's irrelevant to us because it's illegal. Again, as I discussed a while ago, federal law over trumps state law across the nation. So again, please tell your drivers that if they think that going from Schedule 1 to Schedule 3 will open up that guideline, it will not. The DOT rules have not changed. The scheduling has on that part of it will not have effect unless the government comes along and the DOT or DEA changes the rules where it can be done. Highway safety, there is concern about the benefits of it because of that study I mentioned a while ago of a long-term effect of how marijuana affects individuals. On the DOT side, it should not have any effect because it's going to Schedule 3 because it's still illegal to do it. Next slide, please. The problem we run into again about the federal law is, and I'm kind of finishing up on this when I go on to the Clearinghouse, is that marijuana has so many unknowns. It's from that point of view that we're having to research it and do some additional studies on it. The THC is still prohibitive in all the safety sensitive drugs that we see across the country. If they decide to carve it out and make it a non-sensitive drug, then we'll go from there. Next page, please.
I think one of the things we hear often in boot camp, Alan, is a lot of confusion amongst drivers. And you hit the nail on the head in this previous slide about, communicating. It is not legal federally. This is still something that, you have to observe regardless of state laws. Or misinformation. And we hear a lot about, especially when it comes to CBD, misinformation about, is it monitored? Is there THC in it? Is there not? And so, yeah, I think if there's anything in this section we can drive home, at least from where I'm sitting, it's communication about what the laws are in place today, because boy, it trips people up easily. You've seen it, Mark.
Yeah, I would add to that the lack of communication allows your drivers to make their own interpretation,
Yep.
which is very dangerous. And again, with all respect, it looks like it might change at some point in time, but it hasn't changed yet. So I would, we've got a large group listening in today. I would challenge you. It's your responsibility to communicate very clearly and precisely with your drivers. What is current as opposed to what might happen in the future.
Right. Not what could
Yeah.
be, but what is.
Yeah. I just saw a question pop up regarding equipment operators. Uh,
Yeah.
and I'll answer that question right quick here now is, uh, the equipment operator depends on, again, what their position is under that. How the DOT guidelines regarding anybody that does drug testing is, you have to be able to, uh, it's a safety sensitive position. You have to be on the highways. If you have an individual that's on private property, never gets onto the highway, it's your company decision whether you drug test them or not. But on a highway, or any situation you're moving a motor vehicle over 26,000 pounds and a 26 and 1 pound, then it's under the FDI, under the DOT guidelines. So
Yes.
equipment operator, it depends on if it's a grader that does highways, yes. If it's a grader that does proper property and doesn't do anything, never gets onto the highway. Now again, that operator has to drive that truck, that grader to a site, then yes, they're in the DOT guidelines. But again,
So
if you're a
a pallet
individual that
a pallet jack operator though that stays within a warehouse would not be
correct, yeah.
forklift driver. Yeah.
That's strictly under the company's guidelines. Do you have a policy? And again, you obviously, I think most everybody in today's world has that. Your policies really should, your DOT and non-DOT should pretty well be close to the same thing. And the reason being is, you don't want to get in a situation that one day you decide that forklift driver, has a commercial driver's license, never used it. If he's in your system and has a commercial driver's license, you really need to have the same program for both of them. Just protect yourself. And if you decide, okay, I want to put him behind the wheel that day we're shorthanded, I want to have him drive somewhere. Well, that's a situation where you put yourself in risk if he's not in your program, and he's not under the same guidelines you put for the DOT side. What I guess my next step and recommendation would be is that there's so many different agencies out there, as I mentioned earlier, the DEA, the DOT, HHS. You just got to watch everything nowadays and look for if they do change this. I don't think there's going to be again, as we mentioned earlier, there's not going to be a quick change for this. And the reason being is that there's so many people in the industry 100% against this. So from your point of view, as a safety director or as the owner of a company, you need to be able to look at your program, maintain it, do your due diligence, and work in a situation that almost you have to say zero tolerance again. I know there's companies there that give drivers or people second chance, and that's fine. But if you decide to do that, you've got to use the safety professionals that protocol that put them into a program where they're tested based on the usage. So again, from the point of view is that I want to make it very clear to your drivers, nothing has changed. We're going to train our supervisors. We're going to inform our DOT drivers that the remaining is still is an illegal drug. And again, federal law overrules state law. Just because of California or New York or Colorado, or somebody might say it's okay for recreational, it's not okay on the federal level. The next slide, let's go all the way to, keep going, please. I talked ahead of my slides here. The clearinghouse. This is where a lot of folks, I want to make sure people understand the clearinghouse point of view of it is that the clearinghouse, first off, there's no change in the clearinghouse. The clearinghouse is such an important part of your business in industry wise. It's a place where everybody should put, anytime a person is, again, let's just do the steps here. You've got to register. The driver has to register. The company has the driver has to register. And you've got to do with the reporting process where that the individual or the company has to report any problems with that. So again, it's a situation where the clearinghouse, you can go to the clearinghouse anytime, and the problem we had in the past was drivers would be positive, get a positive test, quit that job, and go to another company, and it wouldn't be it couldn't find anywhere in the system where that they ever was positive for a drug test. On the clearinghouse, everybody has to use the clearinghouse. So it's important for you to, again, use the clearinghouse to register your drivers, and you have to report to that. Next slide, please. Again, here's how it works here is that the driver, the CDL or CLP are subject to the drug testing. Employers like CMI drug testing, we have to go through the system and register. MROs, SAPs, they have to do that because, again, the process of if you've got a driver that has a second chance and has to go to through a testing program and return to duty program, then your third-party administrator like CMI will help you do that for you and responsible for helping you do that for you. So again, the clearinghouse is a total process of verification that your driver has never had a positive drug test. If he has, then it better be in that system. Next slide, please. The importance of the clearinghouse. Again, as I mentioned earlier, the companies employers and MROs have to report and verify a positive drug test or refusal to test to your clearinghouse within 3 days. Again, that's very important because if you tell the driver no, you failed the test, and he goes to another company the next day, takes another drug test, and doesn't fail that one, then this is why this is so important. You have 3 days by federal law. The driver has to do electronic consent so that you can do his query on his past history of what he's done. The queries must be run on all pre-employments and also on an annual basis. So again, catches a situation during the year that your driver had a positive drug test and for some reason you didn't know about it. When you run that annual query each year, that will pop up. I'm not sure why that situation would pop up if you're using a third-party administrator. Only situation I guess that could happen would be is that you're monitoring yourself. You don't use anybody. You use your own random program. The driver for some reason was able to avoid you finding out he had a positive drug test. So run the annual query, which is required by law, all pre-employment annuals, then that would catch that situation. Again, the employer return to duty, that's extremely important to use the clearinghouse because, again, your driver will never be able that failed that first test. If he goes through the process and it is clear, and after so many tests has negative test results, if you don't use the clearinghouse, it'll never clear him. It was still showing that he has a positive test result and hasn't done anything to rectify the mistake he made. So again, you can hire somebody from another company that was let go because they have a positive drug test, but you have to still, before you hire them and put them in a safety assistant position, you have to, again, they have to go through the return to duty program and pass the return to duty test. That's why it's so important to do that. On the driver's side of it is, they have access to the records all the time. They can request their history. So that's why they need to register. Again, the last comment is drivers who operate commercial vehicles. Again, back to that equipment operator. That equipment operator might always be on private property, but if he drives that commercial property, that commercial grader or backhoe, whatever he might have, to a property, and drives on the highway, then he's subject to DOT. So from that point, again, you have to be able to report to the clearinghouse if he ever has a positive test or refuses the test. Again, the same thing under the DOT guidelines. If you refuse a test, it's the same thing as a positive test. So, and that has to be reported by you within 3 days. Looking ahead, the next page here, looking ahead, I just don't think there's going to be a situation right now in the near future of FMCSA or DOT retaining marijuana, changing even though his schedule goes to Schedule 3, changing in the program. So you need to be able to, again, monitor the system and monitor and work with your, I guess the best thing would say, I work with your third-party administrator, a company like CMI, that is aware of what's going on a daily basis, and can also changes being made to that situation there. I don't think the guidelines are going to change anything. And from that point, the next slide is, I have one more slide I didn't put there that I'm talking about is every state is different. So I saw there's individuals all across the state. So you need to be aware of your state situation. As I mentioned earlier, I'm in Fort Worth, Texas. Texas has not changed the guidelines. It's a legal drug. As I mentioned earlier, you need to be aware and remind your drivers that if they, again, I mentioned this earlier, if they go on vacation and go to a state that where recreational marijuana is legal by state law, it means nothing to the state of Texas. Texas, if you cross that border, come back to Texas, you're driving, you stop for some reason, you've got marijuana with you, or you could be arrested based on the amount you have with you. Or secondly, is you go back to your job, and you're tested for either DOT or non-DOT. You're positive. On the DOT side, it's federal law. On Texas side, unless your company has a situation where they tolerate or second chance of marijuana, Texas has the right to fire you. So the employer because of this. So again, I just again reaffirm to all your drivers, again, federal law is over state law. And so you just be aware of the situation that recreational marijuana is something you need to avoid unless you've got a prescription. Again, back to that thing, even if you have a prescription for marijuana, it does not trump federal law. I've had customers that say, well, my employee has a prescription because of arthritis or something he might have, or it helps with, I heard it helps with nausea for people taking chemo. I'm not opposed to that. I'm just saying, unfortunately, under federal law, that isn't given the right to drive a safety sensitive position, drive a vehicle on federal on highways just because he has a prescription for it. So again, you need to be aware. You don't want your situation where, again, you're in a lawsuit because your driver has prescription for marijuana because again, he's in a unfortunate situation. He might be under cancer treatment and chemo or something, and he uses it for that situation. It does not affect how federal law rules it, and it does not affect you being in a lawsuit. So from that point, I'll open up for questions for you.
Yeah, we don't want somebody to think they're doing the right thing, think they're doing something legally and have it impact both them safe on the roads, safe with your equipment, and an accident for your company.
Yeah. So
Yeah.
So I want to mention there, I know Texas because I'm here in Fort Worth. I'm very familiar with, I know every state is a little different on the non-DOT side, where I know we're talking about DOT, but again, just across the board, all your employees, the DOT or non-DOT needs to be aware that could have effect on them.
We do have some questions in chat if you have a few minutes.
Yes.
So first from Rhonda Kelly, is there any tentative date for movement from Schedule 1 to Schedule 3?
Sorry, I lost you for a second. Repeat that, please.
Is there a tentative date yet for the movement
from
Schedule 1 to 3?
No, there's not. I have not seen anything in either of my documentation. We looked through 5 or 6 different programs that we have that update. There's not one now. I just don't. things move real slow. And so I just don't see it happening. I don't have no date. I'm sorry.
Okay, so I think, Rana, that means watch for us, watch obviously,
Yeah.
FMCSA, DOT, watch there, and watch CMI, because they will be the first to shout it out as soon as they catch wind
Yeah.
about that.
Yeah.
Well,
Uh,
I got a quick follow up on that question, which is a
yeah.
very good question. We don't know when. Let's assume something does happen. How will that be communicated to the industry? Will that go through the states, or how will they communicate such a major thing?
Well, I think that again, going from Schedule 1 to Schedule 3 could be approved and have zero effect on industry. What will happen will be is that the FMCSA or the DEA are they're going to have to change their so-called wording so that, again, right now only drugs that I'm aware of are on Schedule 1 and 2 are tested on the DOT panel. So they'll have to expand that to include some drugs in for Schedule 3. But I would think that the statewide is not going to do a thing regarding that. I mean, obviously they'll announce it, but from the DOT side, I think that's probably going to be done through most likely your third-party administrators will have the first ones that will notify you. I mean, there'll be a notification going out, big notification that goes out from the FMCSA that it's been approved as Schedule 3, has no effect on drug testing, or it has some change it might be. But again, I think that probably your best bet would be, the quickest way would be is through your third-party administrator company like CMI.
Very good. There was another question in chat from Justin. If a driver gets a positive test, has anything changed on that in the last year?
No. He's still the options are, if your driver gets a positive test, based on your company policy, zero tolerance, he's gone, or she's gone. Or second chances, then you've got to work with a substance abuse professional, and they'll do the program based on the conversation they had with the person who's positive, based on their tendencies. They'll be most likely are taking 6 tests over the next 12 months. And after that period is done, they'll take their last test, return to duty. If they, all these tests they take during the next 12 months are negative, then you can put them back into a safety sensitive position. So nothing has changed.
Okay, wonderful. I don't see any other Jane got a question in right under the wire there. Jane asks, I'd like to clarify, if a driver had a positive drug test, is there a chance to dispute the result if the medication was prescribed to them? If so, how can it be challenged?
Okay, what that is up to is that your medical, that's the plus to having a third party administrator. Every third party administrator like CMI has medical review officers. The first process will be is that the on every positive test, the medical review officer will reach out to the driver. Obviously, if it's marijuana or cocaine or something that's a situation that is pretty clear cut, then they still reach out to them and ask them a couple of questions about it. During that point, there's 2 things you can do. Is every DOT has 2 specimens taken that time, so that the driver can first challenge the test result by saying, I want that second specimen tested. So they have to send it to a different laboratory and it's tested. And the results come back positive. So again, the MRO or medical review officer is going to reach out to the driver. The driver is going to explain to the MRO, okay, I've got a prescription for this. Again, based on the type of medication it is, the MRO can't overturn that positive test or make it a non-negative based on what it is. But there's certain medications, obviously, you shouldn't be driving under taking that medication. So Every medication is different, but yes, the MRO can, if you have a prescription, then it can be turned over to make it non-negative. The negative about that situation prescriptions is it's got to be in their name. I know I've got friends well, I probably have too. My wife has been sick and I'm sick and I took her antibiotic pill by mistake, or I took the pill, or my wife's or arthritis and I'm feeling bad and I want to take hydrocodone for feeling bad. If the prescription is not in your name, it's the same thing as a positive test result. So that's why it's so important, again, to your drivers, they cannot take anybody else's medication because it's got to be in their name or it's a positive test result and it cannot be overturned. So that's another part of the process of working with a MRI. He can overturn it, but it's got to be in your name and he's got to be justification for it. And you've taken it what it's supposed to be. But again, certain drugs still cannot be taken and drive on the highways under DOT guidelines.
Got it. There was a follow-up question to that one. Who's responsible for fighting it? Is that the company's responsibility or the driver or both?
It depends on your policy. Obviously, I know majority of my companies have a situation where that if the driver wants to fight the test result, then they're going to pick up the tab for the second result, the second test, the split specimen. The part of the MRO and the substance abuse professionals getting involved, again, that's up to the company. I have companies that will pay for every test they take. I mean, it could be 6 of them, or it could be 12 of them over the next 12 months. It depends on the substance abuse professional's responsibility on how he thinks how bad. I've dealt with companies that test drivers for 2 weeks, every 2 weeks for 5 months. I mean, that gets very expensive. So you need to have your policy. And that's something the third-party administrator can help you with. Your policy says how you want to dictate if there's a positive test result and you're giving them a second chance. So again, majority of my customers, the driver pays for it out of their pocket for this additional testing. It's just the way it's been across industry. I mean, there are some out there that pick up that will pay for the additional testing, but majority of them, the driver pays for the additional testing, especially that one test where there's a split, where they have to send the specimen to a different laboratory. That gets pretty expensive, and so they'll make the driver pay for it.
Okay. Well, I heard the P word, policy, and anytime I hear that, that lights my ears up, because we know from a legal perspective, if you're going to have a policy, you should always enforce it consistently every time. If you are not going to do that, don't have the policy. So I know that's not quite what we were saying here, but still, it always lights up for me, and it's a reminder. Due diligence is one.
Yeah, a third party administrator will help you with your policy, and that's the key part of it. We all know companies out there that do this, administer it themselves, and do the DOT guidelines themselves, do the random testing themselves, do the policy themselves. Again, from the side of the third-party administrator side, is that we've done this before. We know what we're doing regarding the policies, regarding the random selection. You can never be accused of picking on somebody because it's out of the company's hand. It's in the third-party administrator's hand. They do the selection, and it's a blind selection where that part of it is. So a policy is the key from everything we talked about today, from the DOT and non-DOT side. It does not matter, again, back to whether marijuana is going to go from Schedule 1 to classification to Schedule 3. It's what the DOT FMCSA says, and that's what your policy would back up. It should follow the DOT guidelines, and that's your safest bet to protect yourself from lawsuits, so you can protect yourself.
Out of curiosity, do you see, and this is for everyone in the chat too, do you see misunderstandings around marijuana, THC, um, with any particular generation? Is this something that we're seeing with as our Gen Zs come into the driver's seat?
Yeah.
Are we getting more issues there?
Well, what I've been talking to my medical doctors about, and I read in the industry is that the new marijuana, I want to say the old marijuana, new marijuana is a lot stronger.
Mm-hmm.
And there are also so many synthetic drugs out there that they're putting together that is so much more potent. I guess the plus would be from the go to Schedule 3 is there would be maybe additional regulations. I mean, you right now you buy marijuana some gummies or whatever they call them to sell. There's no regulations out there. I mean, there are companies out there that will probably say, okay, this is our guidelines, this is what the percentage is, and here's how it works. But there's a lot of companies out there that you have no clue that from A to B what the strength of that gummy is. So from that point, you really need to protect yourself. And again, I just think it's a lot stronger now. All the medications that are the marijuana, the synthetic side of it, the drugs versus were in the past. So again, is there any difference between the old and the old generation new? The difference is the strength of the drug. That's the difference.
Mm-hmm.
I would chime in. Yes, I think there's a lot of misunderstanding with our drivers on this issue. Where there is no misunderstandings with our plaintiffs' attorneys. I can assure you they know these rules and regulations and laws inside and out and are actively looking for violations when they get involved in a lawsuit. I can tell you that for a fact.
Yeah, I belong to a couple of associations that we're very fortunate to have some attorneys that are involved that are part of the association and speak on a regular basis. And all they bring up again is consistency. You're doing your policy the same for everybody. You can't, things happen. Unfortunately, terrible things do happen. And all you do is your due diligence to say, okay, here's what we did. We're consistent across the board. We did what we're supposed to do. And it still things go bad. So, and that's the only way you can protect yourself is be consistent with your drivers, your policy, and do your due diligence on monitoring how the drug's affected. But again, I could be 100% wrong. I just don't see, even though marijuana being classified from 1 to 3 will have any effect on the DOT FMCSA. It's just may take some time to again rewrite some guidelines, but they're not going to make any changes until those guidelines are rewritten so to protect the industry. I just don't see it happening.
Well, Alan, thank you so much. Appreciate having you today. Since you were just talking about consistency, I always have to put in a plug too that, we believe that communication is key and consistent communication, consistent application is critical because your greatest asset and your greatest liability is the behavior of your employees, of your drivers. You can only do so much, and then it's up to whether or not they're going to do what they're supposed to do based on, laws, regulations, policy, expectations. So reinforce, don't rely on the yard to tell them how it really is. Work with CMI to make sure that the experts are applying that policy consistently and taking care of those things and watching those regulations. Y'all do a great job. So that's my little plug for today. Alan, thank you. For anyone attending, if you are interested in receiving a trial to access Infinity, we have reasonable suspicion training. We have all sorts of training around this, and you can upload your own custom content. You could upload your policies and get signed off acknowledgments from every driver. If you would like to see more, let us know. Be glad to give you access. Typically the trial is 30 days, but if you just want to pop in and look around and ask some questions, you're welcome to do that too. And again, for anyone who wants to have a certificate of attending today for their NATME points, if you want to just pop it into chat or email us afterwards, we can get you hooked up. Alan, anything, any parting words for us?
No, ma'am. No, thank you. I appreciate the opportunity. It's a subject that's not going to change. Like I said, it's started back in the 70s, and we're still, how many years later, we're still trying to figure it out. So I don't think marijuana is going to be part of the drug testing program, the approval part of it anytime in the future. But anyway, thank you.
Thank you very much. We appreciate you,
Lydia,
everyone.
yeah, Lydia, I would just make a quick comment. If after listening to Alan's presentation, and I would absolutely get something out there to my drivers to clarify exactly where we are with this Schedule 1 to Schedule 3 situation. And I would do that on Infinity's system as custom content, or somehow, some way. This is a need for a responsible carrier to communicate very clearly and precisely where we are on this issue.
Yes.
I know we've got in the system, you've got reasonable suspicion, you've got, all kinds of marijuana use, CBDs, but this is something that needs to be very clearly communicated.
Yes, no doubt. All right. Thank you all. Thank you, Mark. Thank you, Alan. Everyone have a blessed day.
Thank you, Alan. Thank you what you do for our industry, Alan. Send him a thank you on the chat. Send him a thank you on the chat. It's good to have professionals like Alan in our industry that are trying to make this impaired driving issue improve. Thank you very much.